Hi, good morning, everyone, and thanks for joining us. We know how incredibly busy everyone's schedules have become, so we've packed a lot of good stuff into the next 30 minutes, and we've got two great speakers to walk us through our topic for today, which is, of course, fiduciary liability insurance. Before I turn it over to Lauren and Matt for introductions, I wanted to remind everyone there is a chat feature built into the Zoom. If you've got questions throughout the presentation, please feel free to enter those. We'll be tracking them as we go. So by the way of quick introductions, my name is Ryan Gardner, and I'm a managing partner and the head of our defined contribution group here at Fiducient Advisors. Lauren and Matt, we are tight on time, so why don't I turn it over to both of you for quick introductions, and then we can dive into the slides.
Thanks, Ryan. So I'll kick it off. I'm Matt Schott. Great to be with you all. I want this to be highly interactive. So if you have questions, to Ryan's point, feel free to set those up and we can stop and address those. I lead NFP's management and professional liability practice. I have over 25 years experience within the industry, and all of that time has been spent in these lines of coverage, notably D&O and fiduciary liability insurance, which is obviously what we're talking about today. Many, many years ago, much older than my colleagues here on the call, we'll call it the mid-90s, I worked for the last multi-line insurer that was known as Aetna. One of the products, or one of their flagship products, was fiduciary liability. So when ERISA was enacted in '74, three markets started writing the product because of the removal of the exculpatory provisions that ERISA brought based on the Studebaker-Packard case, which is, a legendary case that brought us to where we are today, brought us ERISA and brought us this product. So super excited about discussing the insurance market, what it looks like today. So I mentioned three carriers. Later in the program, in the presentation, we'll talk about how vast that market is today and some of the challenges that clients like yourself and the ones that we handle are navigating through. Lauren?
Hi, well, I can't beat that kind of introduction. Matt, I'm Lauren Kim. I'm the legal and technical leader of the Financial Institutions Group at NFP. In that role, do a lot of policy work, a lot of legal trends and analysis, also work on high level and big claims on behalf of our clients. Prior to this, I was the FI claims practice leader at an insurance company where I handled all of our large fiduciary claims that came in, regardless if they were FI related or not. And prior to that, I was a practicing attorney for almost a decade here in Chicago, where I handled D&O coverage litigation. I also litigated fiduciary matters on behalf of the defense. So just want to put that out there. I'm a good guy. Prior to that, I was, at law school and things like that.
So Ryan, next slide, please. So I think you're all familiar with the ERISA, but a quick refresher: the Employee Retirement Income Security Act of '74. It's obviously a federal law that sets standards. One of the key standards is what we call, and you guys know this, the prudent person rule. That's where the liability comes in. And like any good regulation, like any good legal standard, there is always subjectivity to that, which opens the doors, as you guys know, to litigation from opportunistic plaintiffs, right? So plaintiffs and lawsuits can come from many different angles. The DOL is responsible for enforcing the ERISA regulations, but plan participants, beneficiaries, and other third parties, as you know, can get standing on behalf of those participants to bring lawsuits against those ERISA fiduciaries. Who is covered is a very broad thing under the policy, which is a very good thing to have. It extends to the plan itself, anyone that would be considered a trustee, and the policy can be tailor-made to address any additional legal liabilities that you would face in your role as a trustee. But with that, really what it covers, what it's designed to do, are ERISA created potential breaches of fiduciary duty under its act. Any breach of duty, neglect, error, misstatement, or omission. So it's rather broad. There's another insurance product called the Employee Benefits Liability. Fiduciary liability is really 2 in 1. It includes that EBL, and it goes a bit further in that it covers wrongful acts committed by the fiduciary and or the administrators of that plan. Some examples, and we're going to get into today. We're going to spend most of our time on the proliferation of litigation in the excessive fee space. And I think it'll be important for Lauren to give you sort of the deeper at a high level some of the legal liabilities around a fiduciary and what that excessive litigation looks like. So to the far right of this slide are the traditional claims that we see. Fiduciary used to be a very sleepy product, hugely profitable for the insurers, but starting in 15, where this proliferation of litigation began, starting with proprietary funds, moving to universities, there are over 20 plaintiffs, attorney firms chasing these lawsuits because there's a lot of money to be made in it. So with that, we'll go to the next slide, and Lauren, you can kind of walk them through the liability exposures that fiduciaries would face.
Yeah, so the fiduciary liability insurance, it contains some key definitions, and it's important when you're looking at fiduciary liability insurance that you're really getting these terms nailed as broadly as you can. There's different, you kind of get your off-the-shelf policy, and then you can have some more enhanced policies. And you want to make sure that these definitions in your fiduciary liability insurance are written broadly to kind of capture as much possible exposure that you might have as possible. So you have, your definition of claim, that's the first one. It's usually a written demand for monetary and non-monetary relief, and it protects, your insureds, which are your D&Os, employees, the sponsor organization, various plans. And, these are typically your fiduciaries, the type of people that you would see be sued in a fiduciary liability action. The covered loss is defense costs, which really can be quite high. We'll get to that in later slides, but the amount that defense firms are starting to rack up in terms of their hourly rate for defending these ERISA matters is getting as high as any very specialized security class action defense out there. So we're talking, thousands, if not thousands of dollars an hour for billing attorneys, because it is such a specialized defense. So you want to make sure that, your loss definition is very broad to cover defense costs, settlements, judgments, certain fines and penalties, et cetera. And then the wrongful acts that are covered, again, you want to make sure that this is written quite broadly, but the coverage is for violations of employee benefit law, ERISA, acts or errors or omissions in the administration of the plan, acts or errors or omissions in the insurance capacity settler. So again, these are kind of your major terms you're looking for in fiduciary liability insurance. And it's important that you're really looking to make sure that the policy is responsive and captures as much potential wrongful acts as possible.
Lauren, the only thing I would add to that, I think it's well done. So this is what triggers the actual policy responding, whoever you buy it with. So for the non-insurance experts, you probably have someone at your firm if you don't do it. One of the biggest culprits of not getting a claim paid is when you don't report one. So one of the things we always tell our clients is, when is a claim, because there's a time or a window of time that you have. Now, we always try and get the policy to be as broad as possible, meaning allow as many days as possible. So there's a little bit of leeway. But in any liability line that Lauren and I work on, whether it be D&O and notably fiduciary liability, the late reporting is the biggest culprit of the first fight to have with insurer to just cover that. So if one lesson I can tell you today is, whoever is in charge of the policies you have in place for your respective firms, make sure whoever the designate is, it could be someone in legal, it could be a risk manager function, make sure they know when a claim is a claim on issues like this, especially in excessive fee litigation.
Yeah, that's a really good point. So we have some key provisions here in ERISA, and just in interest of time, I'll kind of go through these a little bit quickly, but here are, the codes, the ERISA codes, showing that fiduciaries, this is an important one, are personally liable to make good to such plans any losses the plan as resulting of any breach. So this is making fiduciaries personally liable, which is, quite a stringent penalty for any losses. And so it's not just, if you're a fiduciary, sometimes you think, if you're like a director and officer, that you're just indemnified and protected by the company, and the company will make you whole in case you get sued. But this is a potential personal liability for fiduciaries, which is quite a high penalty. But there is a solution. Right, if you can go to the next slide. One of our solutions is insurance, right? And I mean, that's why we're all here today. It's an insurance. And here's the code that shows that allows the creation of fiduciary liability insurance, essentially. And it allows them to cover the potential liability. Here we see in section B3, an employer-employee organization from purchasing insurance to help cover that personal liability. So this kind of created the insurance product, and it's baked into ERISA. Ryan, if you could go to the next one. And so I'm going to try to cover in like 5 minutes the history of fiduciary liability, which is something that is near and dear to my heart, and that I actually have enjoyed litigating and then working on the claim side for quite a while. But first I want to kind of, the landmark case was this Tibble case. It's a Supreme Court case that held that there's an ongoing duty under ERISA to monitor investment. So it's not enough for fiduciaries to just sit by and just allow the funds just to kind of percolate in the plan, that there's an ongoing duty to monitor those investments and act accordingly and prudently in selecting investments. However, importantly, under Tibble, they didn't define what ongoing duties really were. So they didn't say like, XYZ, this means you have met it or you haven't met it. So that's an important and a crucial gap that we have in the litigation and in the case history. So different cases and different litigation in courts try to look at what is trending and try to look at each other to say, okay, create a standard on a guidance on what is reasonable. What is an ongoing duty really mean? How often are you checking investments? What do you have to do in terms of removing investments, putting new investments in? So we have some quick pointers here on risk management trends in terms of ways to try to mitigate some of those issues and show that you are responsive to the ongoing duty. I'm not going to read through those. Just
Lauren, can I just add something?
Yeah.
So it's that classic. We're going to tell you what we told you, then we're going to tell you again. There is a lot of discussion around the acronym. Large companies are addressing it, whether it's climate change and what we call ESG. When it comes to fiduciary and what we're talking about, it's all about the G. It's really around planned governance. So if there's anything we can tell you to mitigate risk, and I'm sure all your firms are doing this and addressing this with the right parties, on a later slide, we'll kind of go line by line of what are like table stakes that must happen to be a preferred risk profile in the fiduciary. But you're going to see this bottom kind of things to think about and do come up regularly with the slide. So just wanted to throw that out there from a safe harbor perspective.
Yes, absolutely. If you go to the next slide. Okay, so let's talk like I said, very, very quickly about how we got to this place in excessive fee cases. Because to Matt's point, it used to be kind of like I don't want to say a throwaway coverage, but it was a cheap coverage. It wasn't expensive to buy. The retentions were very, very low. The premiums were very, very low. And why is that? Because the average fiduciary plan was not being sued. This started way back in the mid 2000s. There was one firm out there that was suing the largest 401k plans, those with billions of dollars in assets, tens of thousands of plan participants, like those very, very big plans were the target for one firm. And that one firm did very well against these targets. And so, they brought claims against, lawsuits against 18 of the largest employer-sponsored 401k plans. They made hundreds of millions of dollars in settlement in that. And importantly, for the plaintiffs bar, this one firm earned more than $200 million in legal fees as those cases settled. Obviously, any kind of, that kind of number is going to be eye-opening across the plaintiffs bar. And so as this one firm had more and more success, you saw more and more copycat firms try to jump in and get into the bandwagon and realize, there's a real payday potentially here. So what you saw is gradually in the 2010s, more and more cases were, more and more plaintiffs firms got involved and more lawsuits were filed against less attractive, let's say, targets. This is when you started seeing the lawsuits against 403B retirement plans, large nonprofits. You saw the university cases, unfortunately, around this time. And, it was a lot of this spin-off and this kind of cottage industry kind of popped up of people trying to chase, that $200 million success they saw this one firm had. So at the time, the cases were about these proprietary funds, and it was kind of a hybrid legal theory, is basically saying, one, you've charged excessive fees for the assets in the plan, but also that you're using proprietary funds where the expense ratios are higher than competitors and the performance of the funds is not as good. So that was kind of like proprietary fund. It was a little bit a higher burden because you had to show and experts had to show that, that the funds weren't doing as well as other funds. And if you had moved into a different fund, you would have done better. So that was a little bit of a harder road. What was happening at the same time, I said it was a hybrid model. The excessive fee part of that, they're starting to get really good case law for plaintiffs on the excessive fee part. And the excessive fee part, you don't have to show necessarily that there were other competing funds that were doing better at the time that you failed to select. All you had to do with under the excessive fee side was show that you had just charged fees that were high. It had no correlation with whether or not the fund was doing well, whether there were other funds out there that would have done better if you had selected those. It was only about this excessive fee issue and whether or not you charged fees that were too high. So now what we've seen in the past few years, suddenly there's been an explosion, an absolute explosion of fiduciary liability cases, where in the 2000s, you had 18 of these cases. Last year, we had over 100 cases filed. And the cases that are being filed now are against much smaller plans, less than $1 billion in assets. I mean, potentially just a few thousand plan participants, smaller plans, other nonprofits, other less attractive targets, but it's because everyone has seen that there is a potential real payday here. So you have a ton of plaintiffs, counsels now jumping into the fray. So here, you have 20 firms at least now that are filing and pursuing these cases. And I'll say, back when I was at the insurance company, we were literally seeing this, essentially the same complaint being filed by one firm across the country against just kind of like selecting random targets and just hoping that one of them would hit, because the litigation, it's very hard to defeat early on. It's very hard to get these cases dismissed early on, especially compared to other federal security class action type cases. They're very expensive to defend because there's not an automatic stay of discovery. So it means that you're from, the minute it's getting filed, you're starting to incur defense costs, and discovery defense costs can be quite large. And then, the settlement still remains quite outsized. Okay, so I'm just going to be kind of enough time here. Just move quickly, so this is all kind of an issue where we're seeing a lot of these cases being filed. We were hoping that the Supreme Court would bring a little bit of stability to this in this Hughes versus Northwestern case. It's obviously a very large case, especially in the university and education side. Unfortunately, it did not kind of provide the clarity that we were hoping in terms of the pleading. And in fact, it did show that, it reiterated that there is this ongoing duty that we talked about earlier on Tibble, and it says that you do have to monitor and remove choices that are doing poorly. So, and unfortunately did not provide a lot of clarity, but did reiterate that there is this ongoing duty.
Lauren, I think, yeah, so no, and you have plenty of time because this is the important stuff. But Andrew, you asked a very interesting question that we get asked all the time. But before I do that, I'm the oldest one on the panel here. And with age, they say comes wisdom. So when you talk about these three waves of litigation, really in the mid 2000s and it's going to answer your question, Andrew, I think to some extent, Lauren pointed this out beautifully. It was really the defense contractors, right? I worked on General Dynamics. I worked on Lockheed Martin. That firm, that one individual firm was targeting them because that's where the money was, right? The larger you are, the larger the recovery. That's where I'm going to spend my time. Then as you evolve, fast forward to 2015, and I worked on it, they were really Ivy League cases. I mean, they were attacking the Ivy League schools, as many of you know, based on what they thought was low-hanging fruit to chase that. And then it's extensively gone on and on. What has happened, like any plaintiff's bar, plaintiff's firms, they go where the money is, right? And that they can bring these suits. And once they figure out a way to bring them successfully. So Andrew, a long-winded way of explaining, it used to be, to Lauren's point, a very large client issue, meaning large plan assets. The bigger you are, the more I recover. Now, if you look at the recent filings, and they're extensive relative to what they were years prior, they're targeting under $1 billion in plan assets. They're targeting under $500 million in plan assets. And where they see what they think is egregious, remember that ESG governance of the plan, again, it's low-hanging fruit. They've already got the lawsuit established. They just bring it in and strike. So I don't know if that answers your question, Andrew, but they are swimming. I don't mean to say downstream, but in the smaller entity space. So I'll take over now. Like I told you, we're going to tell you what we told you. We're going to tell you again. What I would use this slide for, and a lot of you are probably doing it, Do the exact opposite with your service providers, your investment managers, and on-plan governance. So for example, we'll just go through one bullet. Don't pay excessive fees unless they're worth it and you've done your diligence, right? Do the complete opposite. Always remember prudent person rule. And I know a lot of you know this. This is the stuff that's really a trustee responsibility, but creates a liability that falls under the contract. Investment management. This is kind of the crux, the first bullet, where Northwestern was like, hey, we want to comply with 404C. We want to give as many options, right? Damned if you do, damned if you don't. You give too many little options, you have a problem. And we all remember the employer stock days. You offer employer stock and you match it. That's a problem. Then you figure, I'm going to solve that and add a lot of options. Well, if you're not monitoring those options, that's really the Northwestern case. It's you guys should have been monitoring. You should have been prudent, and you should be looking at fees, and you should be looking at smart investment options for me, the plan participant. Then lastly, plan governance. You do the opposite here. You've now mitigated as best you can. You can always be sued. It's the reality of the US. But as long as you're doing all the proper governance steps, it helps you mitigate that exposure. Next slide. Remember those three carriers? I started at Aetna, which eventually got bought by Travelers. So Travelers is now a big bellwether of fiduciary liability insurance, and it was Chubb and AIG. These markets are markets that were created in the last hard market back in 2002. But these are markets that a lot of these individuals worked at AIG, worked at Travelers, or worked at Chubb and started facilities here. This is how vast and the opportunity to insure your risk has become. What's interesting is I said earlier, it was a hugely profitable line of business. When they look at customers now that have this excessive fee litigation exposure that Lauren spent some time on and explain what the issue is, they're very cautious about how they proceed. So there's plenty of opportunities to get your insurance through multiple markets. And then it dovetails into the next slide. It comes with a lot of scrutiny. And what they want to understand, again, I keep coming back to the G, what are you doing insured, as a company, as trustees, what are you doing to mitigate all the exposure that if a lawsuit comes in, I know you have defensible actions, to Lauren's point, to try and get it dismissed, not always easy in the ERISA context, like in D&O litigation, but to get it dismissed, that it's an opportunistic plaintiff trying to sue on behalf of participants or any standing party they can, doing all this sort of thing. They're going to send you a questionnaire that's fairly robust. These are the table stake questions that are on there that they want to see how you're responding to it. The better you respond, the better the offer will be from the insurers. Next slide. And then here's anytime claims come in, the insurers want profitability. And the metric they use is combined ratio. For the public companies that do this, Chubb, right? They issue their combined ratio and then they do it by line of business. They're not very forthcoming in specialty lines or management lines. Fiduciary liability, because of successive fee litigation, has created a lot more losses than they ever planned for. So what do they do to treat or correct the action that's creating a lot of losses? They reduce capacity, meaning years ago when I wrote this business on the underwriting side, we'd put up 25 million. Now, if you have a lot of exposure around excessive fee litigation, you won't see 25 million thrown up by one insurer. You may see 5 or even 10. They're going to sublimit exposures, maybe try to sublimit the excessive fee, what we call quarterizing the exposure. We don't ever like to have that done as a broker on behalf of our clients out trying to secure this coverage. The other thing is they might treat again with the specific issue of putting a much higher retention around excessive fee litigation. In addition, and this is a big no-no, but sometimes really large clients have no option, they'll also add co-insurance. So think of your medical plan while you're helping pay the claim that comes in. That's a pretty drastic measure. And then when you get into excessive fee litigation, it always crosses into a class action litigation. So sometimes you'll see both the excessive fee and securities class be much higher than a traditional fiduciary retention. And then these last two are
back when I was at the insurance company, we would sometimes see retentions as low as $5,000, right? And then it was a drop in the bucket because our defense costs, honestly, would get into the multi-million dollars. So where are you seeing retentions now, and how does that compare to, where it's been, maybe even 5 years ago?
Yeah, and this wasn't rehearsed, but great question. It depends on the size. Remember, the larger you are, the bigger the claim generally. So the carriers do try and stratify, and they use plan assets as the key metric. We've seen excessive fee because like the AIG started this trend because they had the biggest book and they saw this before most. Table stakes was 1 million to 2.5 million, in some cases 5 million. And for the really large, as called Fortune 500, where they have, and remember, the complexity of the plans matters too. Excessive fee is really a defined contribution issue. So depending on how complicated the plans are, how many participants size up, you can see upward of 10 million. But I'd say generally speaking, this exposure has been around 1 million to 5 million just for this type of litigation. On the smaller end, $1 billion and under, you might get away with 250, 500, or 750.
I mean, I do remember that the one time we had a retention with $5,000. I was like, that pays for 2 hours of work. So, and we quickly racked up. It was a claim I had. We quickly racked up. I think the case was still ongoing when I left. It was over $5 million in defense costs alone.
Yep. Yep. So, I mean, it seems like there's a lot of them. Fiduciary, like I said, is hugely profitable. This phenomenon of litigation has created some issues for the carriers that write it. And the last thing, in any hard market or where they're having losses, you guys know, just simple principle of insurance, right? Supply demand, premiums need to outweigh claims to maintain surplus. So what they often do a lot of times is, again, increase their premiums to try and restore the balance of profitability. Next slide, Ryan. So this is our bios. Hopefully you guys learned a bit or, were aware of this. Turn it over for Q&A. One of the things Lauren and I pride ourselves on, fiduciary liability and D&O liability. The cool thing about what we do, our policies, I call them snowflakes. They're not like traditional property where carriers write all the same or an ISO form. These are all nuanced, unique forms. And while the intent is the same for a Chubb to insure AIG, the policies are uniquely different. The reason I tell you that, consultants like myself and Lauren, especially Lauren on the legal side, we dig into these policies to make them as broad as possible. So what I would throw out there, Ryan, for the benefit of the audience, we can do pro bono reviews of your fiduciary liability insurance just to kind of give it like a fitness test. Because like I said, we've been doing this a long time, but I wanted to thank you for your time on behalf of me and Lauren. If there's any questions or any comments, we'd love to have them.
Matt, we've got one more. I'm not sure if this is for you or Lauren, but one more question in the chat box here. It says, are there any special considerations for offering a self-directed brokerage option?
Lauren, you want to?
You mean within the plan?
Yeah, my sense is the question is geared around maybe exposure risk. And having that brokerage window, does that offer up any additional risk or exposure to the plan sponsors?
I'd have to think about it. I mean, I think unfortunately so much of it now is tied to like these straight metrics, and it doesn't really. Unfortunately, so much of it isn't even about the way you craft the plan or the funds and that necessary that you're putting in the plan, because all funds have fees. All funds, carry a certain amount of risk with them. And so in my opinion, we've started to lose a little bit of what fiduciaries are supposed to do, because it's all come down to, well, was there an alternative out there that had lower fees? And so you've kind of lost the thread in terms of what you're actually putting into the plan, and as opposed to, well, what else is out there in the whole universe? So you've kind of lost the thread, I think, in terms of what a fiduciary was meant to do and what these plans are meant to do, and what the actual fiduciary responsibility is. So unfortunately, there's only so much you can really do. And to the question before, a little bit is, it's hard to really tell who's going to be hit, because it used to be, you could tell if you're a giant plan that you were going to get hit. Now these very small plans can be doing everything right and be trying to act proactively, and they're still going to get hit because there's just so many firms out there trying to make a payday. Like I said, they have one kind of template lawsuit complaint, and they just sprinkle them all over each other and see and hope that they'll hit a few places, and that's enough to kind of get their fees back.
Well, certainly aside from the insurance question, with the Department of Labor's recent opinion on cybersecurity with brokerage windows and the core menu, it does create some additional complications for plan fiduciaries to think through. So we are right at 11:30. I know we promised at the start we'd be sensitive to time and finish on time. So to echo Matt's comments, and I'm sure Lauren as well, we wanted to thank everyone for joining us today. That was a very quick dive into a fairly complicated and complex topic. So Lauren and Matt, thank you both again. And if there's additional follow-up questions, there's some contact information that was on the screen. Please feel free to reach out to any of the three of us, and we'd be happy to help with anything we can. So thanks again. And as we move into the weekend, hope everyone has a great weekend, and stay well.